Edith Blakeney on behalf of Mr. Pierce, Your Honor. Right now, my client does agree to participate virtually. My client would like to represent himself on this. Sir, can you state your name for the record?
David Pears.
I can't talk to you if I can't see you, Mr. Pierce. Okay. All right. So, Mr. Pierce, you understand that you're being charged with resisting arrest? Is that your understanding?
It's just resisting. That's it. Just resisting.
Resisting and obstructing arrest. Yes. That's what you're charged with.
Okay.
What did you think you were charged with?
It was either just resisting or just obstruction or both. I wasn't sure.
Well, it means it's either or. I mean, I don't know what happened. So it could be resisting, it could be obstructing, but it's
interchangeable.
It's sort of interchangeable.
We're starting strong. I don't know if I was resisting or obstruction. Yeah, right there. You know, we're dealing with a man who knows what he's talking about.
You understand? Okay. Are you currently residing?
Yep.
Okay. Do you work?
Yes.
Where do you work?
I do Uber.
Why do you not want to be represented by an attorney?
I feel like I can represent myself better.
Okay. And how are you going to do that? Are we having a jury trial?
I just wanted to speak my perspective on what happened and basically get the case dismissed. I didn't do anything wrong. I'm 100% innocent.
Well,
so.
You can't just talk. I have to have sworn testimony. I have to hear the testimony of the police officer. I have to hear, you have to have the opportunity.
I forgot to thank people. This was sent to me in Discord by Joey Tink RN. It comes from Court Cam TV. Link to the original in the description below. Also, it was Andrew in Iowa who sent me the Judge Manning. That's kind of fun. That's like hanging out with an old friend.
To testify or not testify. And if you're telling me you want to testify, you need to understand that you're giving up your right to remain silent, that there's no obligation for you to say anything. The burden is on the prosecutor to prove that you are guilty. It's not your obligation to prove innocent. You have to understand how to put in evidence. You can't just speak. You have to put in the appropriate evidence under oath. And, there might be a technical aspect to this that you may end up sabotaging yourself because you don't know the rules. But if you want to do yourself, you certainly have the right.
So if I represent myself, you saying I can't speak for myself on trial? Or is it,
Yeah, you can, but you're not just going to come in here and speak. The prosecutor is going to bring in the police officer. The police officer is going to testify. You're going to have to question or cross-examine them. There's all kinds of things that go on. There's certain things you can talk about. There's certain things you can't talk about. I don't know what happened. I don't know if there are certain things you want to tell me that you're not allowed to tell me under the rules of evidence. I mean, the fact that you don't understand what I'm saying is part of the problem, is that you don't have the training to represent yourself. But first of all, what kind of trial do you want?
I'm pleading not guilty, so and I just want to have a chance to speak on what happened, regardless if that's now or later.
Well, then do you want a bench trial or a jury trial?
What does that mean? She told me earlier, but it's my
bench trial is where the judge is the fact finder. A jury trial is where a jury of your peers from Huntington Woods, Pleasant Ridge, Royal Oak Township, Oak Park will decide you're guilty or innocent.
So the first one, the judge
is the judge, yes. The second one is the jury. And we
like jury, people do jury duty, talking about that?
Yes.
I don't know which one is the better option or where I can.
That's why you often have an attorney to help advise you.
Yeah, we're aware of that, Jackwagon. That's why the judge suggested you get an attorney.
That's why we appointed an attorney to help you, who knows or can advise you on what the better option is. But you don't want an attorney, you said.
Oh, I just want, if I get an attorney, I would just like to represent myself at some point and speak for myself.
Well, your attorney will allow you to do that.
Your Honor, it's
Like,
been explained that he has a right not to testify, which I feel like you've gone into, but you have a right to testify on your own behalf, but you also have a right not to testify. And that is where your words would come out to either the judge or to the jury, okay?
Oh, so I can
Sorry.
get
Okay.
I can get a appointed attorney and still choose to testify. Is what you're saying?
Yes.
I didn't know that. I don't know. This is all new to me. It's my first one.
Yeah, that's precisely why you need an attorney.
All right. So would you like Miss Blakeney to now represent you, get a copy of the police report, and advise you what should happen next?
Your Honor, I'll tender him the police report.
Okay. What do you want to do, Mr. Pierce?
I would like to speak with her as
Okay.
attorney and represent myself though when it's time to, like, I would like to have a chance to speak up, testify.
Just because you testify doesn't mean you can speak and have an attorney, Mr. Pierce. Your attorney will just advise you the process to allow you to speak so that you don't make a mistake.
Mm.
And let me say, the attorney advises you, but ultimately, like you're speaking here, you can decide to take my advice or not. Okay.
Okay.
Because at this point, a lot of this stuff that the judge has gone over, we've gone over. But I mean, it's okay because the judge really can't give you legal advice. That's what I'm here for. But a lot of this we've already gone over, sir. So if I am your attorney, you are going to actually have to conversate with me and listen to what I'm saying. Should you feel like my experience is not enough for you, we can ask for another attorney because I know.
Oh, that's just sad. She seems otherwise reasonable, but this guy's choice is truly to represent himself, which is horrible, or option B is to be represented by an attorney who thinks conversate is a word. I'm not saying it's good.
No, there are a lot of this we've already talked about. So, I mean, it seems like maybe you're not heeding what I've said, or what I've said to you doesn't seem to be important, because a lot of this that the judge has already gone over, we've already discussed.
I'll just have the judge not have the jury trial, like have the jury make the decision.
Your Honor, I'm gonna say I really don't feel like this is an informed decision for him to make right now, because I definitely probably would advise for a jury trial, but
why is that?
Your Honor, I would just, you know what, I feel like I've had conversations with this client, and I feel like my expertise is not being heeded. I don't know why. But I feel like this isn't appropriate. This isn't appropriate to have this conversation on the record. Well, he does need an attorney, but I don't know if he's heeding my conversation. So maybe he needs a different attorney.
What do you want to do?
Because this is just inappropriate. Because this is too much.
I just made my decision. I want the jury.
But I just thought you said you want the judge. I know you just said the judge.
Judge. That was an accident. Judge. There we go.
Your Honor, I would just ask to be removed from this case, because really, my client is just, we've had these conversations. He's a bit confused.
Your Honor,
we're going in circles.
Set this for in-person.
Well, how will that change if it's a different attorney, Ms. Blakeney?
Maybe he'll respect their opinion more. I don't know.
Why would
we can't? Well, you know what? We can. Well, there are a lot of different reasons that I'd rather not say. We can set it for in person. It's just this. I just feel like Right now, some of the stuff that he's saying has already been discussed. We've already discussed. We're just going in circles. And I feel like this
I
is kind
spend
of
much of my day like that, Miss Blakely. It's okay. It's my job.
okay.
I
I
like
mean,
for
yeah, it's 12:30 and I have another docket at 1:00.
Okay.
I agree.
judge trial. I don't want the jury, and I would like to represent myself. No lawyer. Just put it like that. It's no attorney. I mean, yeah.
All right. I am going to set this for a final pretrial. I will request another MIDC advice only so that you can confirm what it is you want to do. And I'm going to reset for final pretrial, July 24th at 1:40.
I'm really enjoying the attorney's pain. It is hard. Professionally, it's hard. We get used to this. We know what should happen. And watching somebody do this it's painful. It's just painful. You know what to do, and they won't let you do it. And you think, okay, okay, just go ahead and touch the hot stove. Enjoy yourself.
Appoint advice only MIDC. All right, you can make your final decision on the 24th of July. You need to be back here at 1:40 on the 24th.
I mean,
Thank you.
Your Honor,
Do
I'm
you give
sorry,
me
did you set a
the ID
bond?
number?
It's the same ID number, Mr. Pitt.
Okay. All right. Thank you. You said 140
Yes,
July. Put it in my notepad. July. What again? 20.
July 24th at 1:40.
Got it. I put it in my notepad.
All right, I'm allowing you to withdraw, Ms. Blakely.
Thank you, Your Honor.
Thank you. Appreciate it.
All right, Ms. Safarasi. This is position 11, Bostic 24, PI 001578, Tariq Jamal Barnes. 40, wait, what is this? This is $25,000 good bond as of April the 25th. Wait, hold on a second. It's more, that's the, okay, here's the thing. Ms. Jackson, that's all I have on here. Some of it says released on original bond, released on, and I don't know what that bond is. I couldn't find that bond order.
I can explain it, Judge.
All right, so it's cruelty in the first, battery, 2 counts of cruelty in the third, and 1 count of criminal trespass.
Judge, it's only going to be cruelty in the first 1 count. One of the cruelties was dismissed at a preliminary hearing. Those other charges that you named out, he already posted bond on. That's why.
Warning, this is a serious and not fun case, but the attorneys and parties get into it, and it's fun to watch Judge Manning deal with it.
It says release on original bond for those charges.
Okay,
He's already paid bond. It's a separate case. They duplicated it. I try to get it all dismissed, but they've just put it as release on original bond.
all right, go ahead.
So Mr. Barnes, Judge, he's been in 120 days. How this case derived is the complaining witness is his ex-girlfriend's son. This incident actually happened about 6 or 7 months before his arrest. The girlfriend did not report it to police before then. The only reason she's reported this incident is after that they broke up and got into an incident. Then she reported him for this particular case. So what happened was there was an incident and he bonded out on those charges. And then she reported him for this incident that happened about 6 months prior to his arrest. And then they no bonded him, Judge. We went to prelim. They dismissed it. It's 1 count. The allegation is that essentially he was disciplining the child with a belt. And so the allegation is that it went too far, essentially. Our defense is that that's not quite what happened, and that's really that the mom is creating a bigger mess for him. And that's just a little context about what's going on for Mr. Barnes. Like I said, Judge, he's been in 120 days. He can't afford this bond. and the state is not moving on this case. We do have a good address for him here in Georgia, and he can stay away from the incident location as well as the complaining witness and his mom. He does not have contact with them. He has no reason to have contact with them, and he does not want contact, Judge. So in terms of likelihood to reoffend or intimidating witnesses, we do not have that here. This is an isolated incident. And so, Judge, because of that, I'm asking for a reduction to not exceed $7,000 total.
All right, so is he gonna live in Fulton County?
Yes, Judge.
All right, go ahead, Ms. Jackson.
Judge, I may have missed it, but did Ms.
Oh, I'm
Bostic-
sorry. Do you want to hear from Ms. Riley? Ms. Riley, if you take yourself off mute, if you can raise your right hand, ma'am. You swear affirm testimony you're about to give, there you go, your military right. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth. I can't hear you.
We
Yeah, still
can't.
can't.
Riley.
So Ms. Riley, you may have to connect to a different audio. If you're going through Bluetooth, it may not be working, but while you're trying to work that out, I'll hear from Ms. Jackson.
And Judge.
Can you hear me, ma'am?
All right, I can hear you now. Go ahead. I just want to know your position on bond.
Hold on. Repeat that for me, ma'am. Hold on. I might.
Perfect.
Can you hear me better?
Yes, I just need to know your position on bond and having contact.
Absolutely not, ma'am. The
So-
issue is that there was a case in Cobb. He was released on bond approximately a month after he offended. It was against my 5-week-old baby at the time. And
So I know that Ms. Sarfarazi is going to object, so the cop, I just need to know about, you don't want any contact, right?
Yeah, this isn't a preliminary hearing. You were very specific on what, and also he's entitled to a bond. Just so, and he has.
I'm having a hard time hearing you.
All right, why don't you
And
just,
hold
why don't
on,
you
give
just,
me
why don't,
one
no,
moment.
why don't you, oh,
There we go. That's much better.
all right, Ms. Riley, why don't you listen, let me hear, I'm gonna put you back on mute and let me hear from Ms. Jackson. Go ahead, Ms. Jackson.
Judge, did I miss Ms. Bostic going over Mr. Barnes' criminal history?
Hmm?
He skipped me.
Oh,
Okay, we would need to hear that, because it's
Great.
extremely.
wow, see, she don't even speak when I do that.
Miss Safarazzi started talking first, Judge,
Well,
to get that information correct.
Boss,
he
you
has-
gotta blame me.
He has 4 cycles. He's on probation out of Cobb for simple assault, battery, cruelty sentence earlier this year for 12 months. Out of New York, there's 7 cycles. There's a criminal possession of a weapon and then 2 old felonies, or a couple for robbery and criminal seal, nothing further.
All right, go ahead, Ms. Jackson.
Judge, I did speak to Ms. Riley before court started today, and she did have a lot of information about prior incidences with them. Ms. Safarazzi's indication that Ms. Riley is just someone trying to make a big deal out of this case is actually extremely disheartening. Mr. Barnes is alleged to have beat a 9-year-old so bad that they peed on themselves and was unable to sit in school the following day. The case in Cobb County, as Ms. Riley just said, is a case against a 5-year-old baby.
Judge, I have to object to this case with Cobb County. We're not here for Cobb County. He is sentenced. It's done.
Actually,
you need to
he
stop bringing
agreed.
up. Hold on, you
Actually, he agreed
objection
at
to
the-
Ms. Riley speaking whatever she's about to say, Judge. Objection to everything. We're not here for Cobb County. We're here for this one case in Fulton County. Can we please focus in on what we're here and what is before the court? The court is here not to talk about Cobb County. We are not in Cobb County. We are in Fulton County.
Judge, I'm extremely alarmed that Ms. Safarazzi is putting up such a fight to bring in this person's criminal history, which we put on the record on every single case. Again.
To get
there
into
is-
the facts of that allegation, Judge, I'm objecting. We have the conviction. We understand there's a conviction, a prior history. We don't need to
Hold
get
on,
into
hold on. Y'all are about to make Ms. Jones mad, which is 10,000 worse than making me mad. One at a time.
And if it's Ms. Safarazzi's time to speak, then the state is happy to wait. But if Ms. Safarazzi can hold on while victims speak and while the state speaks, then I think that would be the proper court decorum. Ms.
I'll let you
Safarazzi?
respond.
I will make my objection when I see fit.
Go ahead, Ms. Jackson.
Okay, and I'm gonna continue to speak. As I stated, he has a criminal history that is extremely relevant because it is identical to the facts in this case. In Cobb County, he has a case where he slapped or battered or assaulted a 5-week-old baby. So your indication that this has never happened, that this is some type of one-off that would never occur is inaccurate, and the state has a right to respond to that. As you see, Ms. Riley has appeared today because she is extremely afraid for her and her children's life. And so if you think that the state is going to sit here and let you make a mockery of this court and of this victim because you don't think it's a big deal, then you are absolutely incorrect. Mr. Barnes has an extremely dangerous history. He committed these crimes. He has open cases. He has a probation case, all of which the victims are the children of Ms. Riley. If Ms. Safarasi thinks that's not important, then that will be for the court to discern. But as for the state, that is a very extremely dangerous person, and he is a danger to the victims in this case. He was a danger in Cobb County. He's a danger in Fulton County, and he deserves a bond that is reasonable under the facts of this case and the history that he has for himself. That is a conviction, not an allegation, as you like to normally say, Ms. Safarasi. He was convicted of assaulting a 5-week-old baby. So that is relevant to this case.
Judge, objection. The case before you is not about this 5-week-old child. That is not what's before you. It's about a 9-year-old that had happened allegedly 6 months that she failed to report until this alleged Cobb case had happened, Judge.
Hold up. Ms. Jones, you need to take yourself off mute and yell at him.
Judge.
Yes, ma'am.
Which Jones?
Hey, y'all.
Tiffany Jones.
Yeah, I really need everyone to speak one at a time. Honestly.
You don't even sound that mad, Miss Jones.
I know it may be. Listen. It's being recorded.
All right. So, if you're finished, anything else, Miss Safarasi?
Yes, Judge.
This is actually kind of interesting in that I'm accustomed to this. This is getting chippy, but I call this appropriately chippy. They are both right. They are both advocating for the position they should be advocating for, and they're serious about it. I would be saying the same thing if I was sitting at either one of their desks. So that's just the process we have. And sometimes it gets a little elevated, but this is still professional, in my opinion.
Again, like I said, this is not what we're here before. If this case was so important to the state as she wants to make it believe, why is he sitting 120 days without an indictment? Where is the state moving on this case, Judge? He has a bond. He is entitled to a bond. We are here because he cannot bond out, and the state is not respecting his rights as well. These are allegations. What is before you today, Judge, is an allegation. That is not a conviction. I understand we want to keep referencing this Cobb County case. Fine, that is a conviction. You can take that into consideration as a conviction, Judge. But in terms of what is before you, that is just trying to murky the water of what is before you, Judge. This is a case not involving that child.
This is interesting to me because there's enough record here that I think this guy's probably a bad guy. But his attorney's pointing out some stuff like this isn't a new allegation. This is her going after him. And I'm not saying it's not relevant, but this is what courts are for. We need testimony. We need to figure out what's going on. That's where they're headed. I'm saying all the right things are happening here because maybe he did this, or we might have a case. Love, exciting and new. Because the timing of that is suspect. And again, I'm not saying, oh, this guy's right. I'm not saying that. I'm just saying that she is going after this guy hard, and then she's bringing up allegations that are prior to the last thing. I think that there's also some emotion involved here that may be beyond justice.
Judge, and also we can rectify all of this by the state indicting this case and moving forward, so we can have our day in court, or B, you can have a stay away, no contact. Judge, my client does not object. He has no reason to have contact. So there's no reason why anybody involved in this case should be afraid.
Stop. All right, Ms. Safarasi, I got what else, Ms. Riley? What else?
I feel like I'm not being heard, Your Honor, and it's really regarding me and my 4 children. When you've been abused for years by the same individual, you don't report things right away because you're fearing for your life. My son is in the vehicle right now. If you would like to speak to him about the abuse, then you are more than free to do so. He's in fear of his life. I am in fear of my life. My daughters are in fear of their life. We look over our shoulder everywhere we go. He has been released on bail, and he has definitely repeated As a matter of fact, when he was released on bond the last time, he was out on bond for 3 years, and he did worse things than he did the first time he was released on bond. This time, the abuse not transferred only to me, and to my newborn baby, it transferred to my oldest son. And my son is the sweetest child. He makes straight A's, and he has known this child since he was 2 years old. And so he has a hatred for us, and he has reoffended several times, and I have forgiven several times. But it's like when you let them out on bond, who knows how long this case is going to go back into court for it to be defended. And then at worst, we could be dead by that time. And so I'm really depending on you guys today to make a right decision based on the criminal history that he has had in the past, violent history, and he has pled guilty to the one in Cobb. And you say it doesn't matter, but he violated his bail the last time. The bail was violated last time, and he still left without any charges, and he still left with no jail time. He still left with just probation. And so now we're giving him a slap on the wrist every single time. And there's no comfort and no security for me and my children's safety. And as she's saying, let's forget about Cobb. Tell these children to forget about Cobb. Tell me for every time I've lost my home trying to escape this man, tell me to
Translation, she found him cheating again.
forget about Cobb. Tell my daughters who have lost their dad and seen them abuse me, tell them to forget about Cobb, because that's ridiculous. And then tell them to forget about in Fulton County when they had to see their brother be abused and recover from being beat on and being scared to death, locking themselves in the room and then double locking themselves in the closet. You tell them to forget. Tell those children to forget the trauma that they've experienced by the hands of this man, by hearing me getting beat through the walls. Tell those children to forget every single memory that they have of me getting dragged by my hair in the kitchen, getting sliced across my forehead by a knife, and tell me that he's not going to reoffend. And then when he reoffends, put the blood on your hands.
Okay. All right. Thank you, ma'am. And I don't know what they did in Cobb, but this ain't in Cobb County. All right, so we got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. If it's available, you're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, and medical, the only reason you leave your house, and report to probation if that's what you've got in Cobb County. No further contact with Benjamin Tate Riley, Tiffany Riley, let's see, Ayana Riley, or any other children. Let's see. As a matter of fact, stay away from all children unless they're your relatives, but none of her children, none of their children, nobody else's children. Stay away from 531 Carlton Point Drive in Palmetto, Georgia. Also, I think I already said no drugs, no alcohol, no weapons. Even if that ankle monitor is not available, sir, you will have a 24-hour curfew. Those are the only reasons you can leave. I'm leaving it at $25,000. Best of luck to you, sir. Is that it for you, Miss Safarasi?
Yes, Judge.
All right. Have a good holiday.
You too, Judge.
All right. Let's see. I'll take you next, Mr. Melnick. I got Sharon Harris.
Well, there you have it. That's all I had. It was nice. It was nice to see Judge Manning. I miss Judge Manning. She's the only judge I ever. If I don't do a video on her for a while, if a month goes by or something, I get a bunch of comments like, "What? Why aren't you doing Judge Manning videos anymore?" There was never a point where there was a conscious decision not to do Judge Manning videos. It's just a matter of if something interesting happens and it gets sent to me. It's really that simple. It's really that simple. I always enjoy spending a little time in Fulton County with Judge Manning for some pre-trial good stuff. Happy 4th, everybody. Behave yourselves. Don't get arrested. Don't blow your hands off the firecracker. I'm not bailing you out.